Members, today we're going to hear House Bill 151 by Representative Valarie Hodges. Staff, please read that bill into the record.
Members, House Bill 151 by Representative Hodges prohibits the creation of sanctuary cities.
I think she's going to be joined by our Attorney General Jeff Landry. And while they're taking their seats, I have the fortune of having my district attorney here, the greatest district attorney in the state of Louisiana, District Attorney Jerry Jones, Washita, Morehouse Parish.
Okay, I have to beg to differ.
And Jay said he's ours. That's right. Representative Hodges, on your bill. Good morning and welcome to the committee, Attorney General Landry.
Thank you, Madam Chairwoman.
Good morning, Ms. Chairwoman and members. I want to thank you for hearing this bill this morning. I've been trying to explain to a few people what a sanctuary city is. It's kind of a new concept, and so for those of you who may not know, I'll just give you my definition and my interpretation of different things that I've read and what a sanctuary city is. So I think we need to start there so we have an understanding of what it is. And basically, it's when
Representative Hodges, I just want to inform the committee that in your packets it's the substitute bill to House Bill 151, and that's the bill that Representative Hodges and the Attorney General will be discussing today.
Okay, so what a sanctuary city is when the sheriff or law enforcement refuses to be in conformity with the federal law and honor an ICE detainer that Homeland Security has or HRO has, and to release someone into their custody who's committed a crime, and Homeland Security has a detainer for that person. And so that's one of the things, and basically what it does, it gives people who broke the law a special protection and from being released into the custody of Homeland Security. And so this poses a real serious national security threat and a threat to law and order in our country. This is America. Obviously, I believe every one of you agree with me. It's the greatest country in the world. And I don't know if many of you remember or heard about in 2015, there was a case, her name was Kate Steinle, was walking along the pier in, I believe it was San Francisco, with her daddy, and there had been an illegal immigrant that had been held on charges, and then he was released, and he went and murdered her in front of her father. And the police had, the Homeland Security had asked for him to be released into their custody, and the local police refused to do that, but instead they let him go, and he murdered that woman. And that's just devastating to a family. And so we want to be proactive and realize that things like this can happen here in Louisiana, but we want to avoid that. Basically, all we're asking is that every municipality, every city in Louisiana comply with federal and state laws to protect our citizens and to keep them safe. And pretty much that's what the bill does. It prohibits the creation of sanctuary cities, and if a municipality or city has adopted a policy saying that we're a sanctuary city, we will not cooperate with ICE detainers, then basically that they would be prohibited from going before the bond commission for projects for the next year. So I'd be happy to answer any questions.
Representative Hodges, the gentleman to your left, do we have a card for him?
Yes. Can you fill out a card?
They should have, I think my staff filled
they
out a
did?
card for him.
You want to introduce yourself?
Sorry, Madam Chairwoman.
Not a problem.
Oh, thank you. Thank you.
Would you like me to introduce him for you?
He can just state his name and
Okay.
address for the record,
Right.
and who he's with.
Chris Kobach.
Okay.
You want my address? 4701 North 130th Street, Kansas City, Kansas.
Thank you. And you are the Attorney General?
Secretary of State. Of
Secretary of State for the state of Kansas. Welcome to Louisiana.
Thank you.
Hopefully Representative Landry is going to ensure that you spend some of your dollars in our state by taking you to some of our wonderful tourism spots.
I've been told about the crawfish. I'm already hungry.
Good deal.
Okay. You gonna go?
Thank you, Madam Chairwoman. Again, I'm joined here by Secretary of State of Kansas, Chris Kobach, who was one of 4 executive consuls to U.S. Attorney General John Ashcroft. He was the chief legal immigration advisor to General Ashcroft after 9/11. So I look forward to having him participate in today's testimony. I want to again thank you for the opportunity to address your committee on what I believe is a crime issue that is plaguing our country now for years, and unfortunately has the opportunity to plague our state. As Louisiana's chief legal officer, I'm committed to ensuring that the rule of law is followed by everyone. Like each of you, I took an oath to defend the Constitution, and this pledge shall not be broken. Unfortunately, sanctuary policies undermine justice and the rule of law. They jeopardize public safety and have a burdensome financial toll on our state government. There are tens of thousands of illegal immigrants living in Louisiana, costing potentially hundreds of millions of dollars to our taxpayers. Sanctuary policies encourage further illegal immigration. They undermine anti-terrorism efforts and promote underground economies that sabotage our tax base. These policies also waste much-needed public resources as they force the federal government to find and arrest deportable criminals already taken into custody by local law enforcement officers who are forced to release them. Since you all worked so tirelessly during the special session to close the enormous budget gap here, I would like to share some relevant financial facts that come from our author's immigration task force. Over 5,300 illegals currently receive SNAP benefits, also known as food stamps. Illegals are placing a $3.2 million a year burden on our state's prisons and are costing our Medicaid system $16 million a year to cover their health care costs. These numbers were before New Orleans issued their policy guidance to its police officers requiring them not to inquire about the immigration status of suspects they encounter and not to cooperate with federal authorities. I'd like to just give you an example of how this affects us. In July of 2015, 32-year-old Catherine Steiny was shot dead while strolling on San Francisco's Embarcadero with her father. The alleged shooter was a felon, a 5-time deportee, Juan Francisco Lopez Sanchez, an illegal immigrant from Mexico. The issue here is that when they had picked him up for a minor offense prior to the shooting, law enforcement did not have the ability to contact ICE. If they would have contacted ICE and put him in the deportation channel, he would not have been able to shoot this young lady. I would tell you that at a time of fiscal distress, you have an opportunity today to combat this toll on our state's economy. It is also interesting to me that some people will support the harboring of illegal aliens, but those same people put an onerous burden on businesses not to employ them. Now think about that for a second. You're going to invite people into your city, and you're going to tell them that they can't be employed. If they can't be employed, what kind of conduct do you think they're going to partake in? So again, I think it's important that we align our policies on illegal immigration. By supporting this bill, you have the ability to clearly say that no one is above the law. These policies, sanctuary policies, allow illegals to commit crimes and then roam free in our communities. The example earlier that I mentioned, it is an immense threat to the safety of our communities. ICE, Immigration and Customs Enforcement, recently revealed that 1,800 illegals released by sanctuary cities last year were later arrested for over 4,200 times, committing 7,400 plus new crimes, including rape and child sex abuse. Unfortunately, only 1,100 of those were not given to ICE and are considered currently at large. Besides the fiscal and legal issues, there are many health concerns. For example, before my son went to kindergarten, he had to take a laundry list of shots just to get into kindergarten. By allowing people to come into this country illegally, we have no way of adequately ensuring that our health concerns in this country are properly in place. The reason that we have legal immigration is to ensure that when people come into this country, there's a process. Part of that process is immunization. There's also an anti-terrorist component. Basically, when you have a sanctuary city, you just as soon put a sign at the gate of that city saying terrorists are welcome here. Foreign terrorists such as ISIS, who travel through Central America into Mexico and through our borders, have the ability to travel to a city like New Orleans, which is attractive to them. Because they know that if they're in that city and they commit minor offenses, the ability for them to be revealed is basically eliminated. Our law enforcement officers don't have the ability to check terrorist watch lists against potential terrorists because of these policies. The citizens of our state and those who travel here from across the world deserve a Louisiana where our officials are not actively undermining the rule of law. I encourage you today to think about these issues and support Representative Hodges' common sense bill that says that no one is above the laws in this country. Thank you so much, Madam Chairwoman.
Thank you, Mr. Attorney General. Of course, we would love to hear from you.
Thank you, Madam Chairwoman and members of the committee. As you've heard, I currently serve as Secretary of State of Kansas, but I'm chiefly here in my capacity as former counsel to U.S. Attorney General John Ashcroft. In that capacity, I was his chief advisor on immigration issues and some of the things we had done during the Bush administration to try to increase cooperation between federal authorities and local law enforcement. I've also represented ICE agents in federal court and represented cities and states that are trying to deter illegal immigration. So I'm familiar with the preemption and other legal issues involved here and be happy to answer any legal questions or other questions you might have. A few quick notes about sanctuary cities. So you've already heard what they are. The most famous sanctuary city is San Francisco. In 1985, San Francisco became the first sanctuary jurisdiction. They adopted essentially a don't tell policy. That is, if the local police find out that a person in their custody is unlawfully present in the United States, they will not pick up the phone and call ICE. The official policy prohibits that. In 1996, Congress heard about the sanctuary policy in San Francisco, and Congress said, we got to stop this. So Congress passed a bill, and the law is found at Title 8, Section 1373 of the U.S. Code, and it prohibits sanctuary policies. But Congress somewhat naively thought, okay, we're done. All we have to do is say you can't do this, and no city or state will adopt a sanctuary policy. Well, you know the rest of the story. Cities and states across the country have ignored that federal prohibition, and that federal prohibition didn't come with any penalty. Nothing happens to you if you violate this law, and so many cities and states have. And the results have been devastating. You've heard about the Katie Steinle murder, which was in the news in 2015. There are many other cases. What happens is local police have in their custody an illegal alien who has a long criminal history, but then they have to release him. They can't pick up the phone and call ICE, even though this criminal illegal alien would be at the top of the priority list for deportation. Let me tell you another case. 2008, a guy named Edwin Ramos. He was a member of the MS-13 gang. I'm sure you've heard of that, one of the most violent gangs in the Western Hemisphere. He was arrested by San Francisco County authorities. He was in their custody. He'd been arrested multiple times. They knew he was a gang member. They knew he had been in the country illegally, and they wanted to call, the officers presumably wanted to call ICE, but the policy wouldn't allow him. So they released him back onto the streets in San Francisco. 4 months later, in the summer of 2008, the Bologna family was driving home from a picnic after church. Mr. Bologna and his 3 sons were in the car. They were driving through one of those narrow San Francisco streets, and the cars kind of slow down to get past each other. As they're passing a car, this guy Edwin Ramos pulls out a gun and unloads his gun into the Bologna's car, kills the father, and Anthony, Michael, and Matthew Bologna all die. Father and 2 sons. The youngest son witnesses the slaughter around him and survives. If that San Francisco policy had not been in effect, the Bolognas would still be alive today because Ramos would have been the highest priority for deporting. So that policy led predictably to eventually someone getting killed. And you can say the same thing about the Katie Steinle case that we've already heard about. There are now, believe it or not, over 300 sanctuary jurisdictions in the United States, and they're spreading. One study found that those jurisdictions led to the release of 8,000 criminals, not just garden variety illegal aliens, but criminal offenders back onto the streets in a single 8-month period. Of those 8,000, nearly 1,900 committed a subsequent crime and were rearrested when they should have been turned over to ICE and deported. In 2014, a new form of sanctuary jurisdiction occurred. So those are the old sanctuary cities. Don't ask, don't tell. We don't talk to the feds, and we don't talk to the person about his status. Now we've got a new kind of sanctuary jurisdiction, and you are seeing this in Louisiana. It's usually a sanctuary county or parish, and this policy is this. It says if ICE calls us and says, please hold on to this person, we're going to come pick him up. We, the parish, refuse to hold on to him. We will not honor an ICE request, which is called a detainer. Why in the world are these counties and parishes doing this? In 2014, the ACLU convinced a federal judge in Oregon that the ICE piece of paper, the detainer request paper, didn't have the magic words probable cause on it. And therefore, there could be a Fourth Amendment violation. Well, as soon as that case got started, ICE changed the wording of the paper. And so it now includes those magic words. Well, never mind. The district judge said, well, the old ICE paper doesn't work. And so the ACLU deceptively sent that ruling to sheriffs across the country. And many of them just rolled over and said, oh, no, the ACLU is going to sue us now because apparently there's some Fourth Amendment problem, which, of course, no longer exists because they changed the form. And that's why you've seen county after county, parish after parish, and roll over. And these are especially dangerous policies because when ICE is calling you, that's because ICE has already identified this person as a gang member or an extremely dangerous criminal that's at their very top of their priority list for removal. This is someone they really want to remove from the country. You have two sanctuary parishes in Louisiana just in the last couple of years, Orleans Parish and Lafayette Parish. Orleans Parish, I think you have the policy in front of you. It's adopted a policy whereby it refuses to hand over an illegal alien unless the alien's been charged with murder, rape, aggravated kidnapping, treason, or armed robbery. All other crimes, doesn't matter. The parish is going to refuse to hand over the person to ICE. Now, I don't know about you, but I wouldn't want to say that I'm not worried about any criminal unless that criminal has committed that list of 5 crimes. The Lafayette Parish has adopted a policy whereby it refuses to hand over a criminal illegal alien unless ICE first goes to court and gets a court order. I can tell you as someone who's been involved in federal immigration enforcement, ICE doesn't have the resources or the time to go get a court order every time they want to pick up a phone and ask a local sheriff to please help them by holding on to the alien for a few hours so they can come pick him up. And so effectively, it's impossible for ICE to come take custody of these aliens. And then, as I'm sure you all know, on February 28th of this year, New Orleans adopted a sweeping sanctuary policy that combines both aspects. It's the old San Francisco-style sanctuary policy combined with a new kind of policy where we won't honor an ICE request to hold on to this alien for a while. It's particularly dangerous. I would say this policy goes even farther than San Francisco's does because it includes the new aspect of refusing to cooperate with ICE. And it also goes way there. Some of you may know there was a consent decree issued in federal court that touched on some of these issues. This New Orleans policy goes way beyond what is required by that consent decree. In no way did the consent decree require New Orleans to adopt a sanctuary policy. So let me conclude by mentioning how this bill works. I've looked at HB 151 and consulted in its drafting. It defines sanctuary city broadly, or sanctuary jurisdiction broadly, so it covers both the old style and the new style of sanctuary jurisdiction. And it encompasses the policies that we see in these 2 Louisiana parishes as well as in New Orleans. The enforcement mechanism is a powerful one. Any jurisdiction that violates this law loses the ability to obtain bond approval from the State Bond Commission. It's a powerful financial incentive that most local leaders will not take lightly. The arbiter of whether or not a jurisdiction is in violation of the anti-sanctuary law is the Attorney General. A similar provision with this kind of enforcement mechanism has been passed by the state of Missouri, and I consulted with them in that. That was in 2008. And they're the same situation where they define sanctuary policy. The Attorney General decides if there's any question of whether a jurisdiction is a sanctuary city or not. The only difference is they deny all state funding to the jurisdiction as opposed to state bonding approval. But the effect is a powerful one. Not a single city in Missouri or county has become a sanctuary jurisdiction with that law in place. None of them want to risk the ability to gain the money from the state. There are other anti-sanctuary laws passed. Utah has one and Oklahoma passed one. And if you have a copy of my testimony, there's a map at the back of it. And this map is a a list of sanctuary jurisdictions across the United States, and you can see the 3 that have popped up in Louisiana. But if you look, Missouri doesn't have any, Oklahoma doesn't have any, and Utah doesn't have any. Why? Because the states took action to prohibit them. And that's where I want to end here. I've been working in this area from the U.S. Department of Justice level, as a private attorney, as a state official. The only way to stop sanctuary cities is for the state legislature to act. You would say, well, hey, the federal law already prohibits it. Just take them to court. It's very difficult. I attempted a long shot case with the Bologna family in 2008. You have to have standing. You have to have a private cause of action. You have to be able to get around sovereign immunity questions. And more often than not, if you try to challenge a sanctuary policy in court, you're going to stumble on one of those initial threshold questions. You're not going to get the question before a judge. The cities that have, the states that have effectively stopped sanctuary policies and protected their citizens in doing so are those that have adopted a statewide law like this one that prohibits the cities from acting in this way. So if you want to take seriously the ability to protect your citizens and visitors to New Orleans from this very real threat, then I would tell you, you have to adopt some statewide law to do this. There's just no other way that it's going to happen. You're not going to see the federal government coming in and stopping the cities. You're not going to see a private lawsuit likely succeeding to stop these. But if the state takes action and uses the heavy financial incentive that this bill imposes, then you can actually do something about it. If you do nothing, I would say it's only a matter of time in New Orleans. New Orleans is a popular destination like San Francisco. They now have a sanctuary policy that's more radical than San Francisco's. You have a pretty high population of illegal immigration in that city. Maybe not quite as high as San Francisco, but it's only a matter of time before someone who is released back onto the streets goes on to commit a crime of violence. And I just hope that you guys can act before that happens. I mean, it's almost inevitable because of the high numbers of aliens and high numbers of people there. So I encourage you to adopt HB 151, and I'd be happy to take in your questions.
Thank you, Secretary Kobach. When you say it's only a matter of time,
What I mean is that if the sanctuary policy continues in New Orleans, that means that on a weekly basis, multiple illegal aliens who are in custody of law enforcement are being released back onto the street without a phone call being made to ICE to say, hey, this guy's violent, it appears to be a gang member, would you please come pick him up? Or ICE may be calling New Orleans and saying, could you please hold on to this person for 4 hours? We'll get an agent over there quickly and pick him up. So those illegal aliens are being released back onto the streets. The ones who would be protected by the sanctuary policy are predominantly ones who are already being arrested for some crime. So they're already high-risk individuals. And it's only a matter of time before they commit another crime. And that may involve injury or death to someone.
Vice Chairman Johnson for a question.
Thank you, Madam Chair. I want to thank all of you, the 3 of you leaders, for being here today. Mr. Secretary, thank you for that compelling testimony. You're an expert, and we appreciate that. And Mr. Attorney General, grateful you've helped take the lead on this. I think it sends an important message for our state. And Representative Hodges, thanks for bringing the bill. I'm wholeheartedly in support of this because of the message that all of this sends. If we don't act now, I think that we are headed down a dangerous road. It was 2 centuries ago, John Adams famously said, he was distinguishing a republic from an empire. And he famously said, we are a nation, a government of laws, not of men. That's what distinguishes us. That's what sets us apart. And I think sanctuary cities breed disrespect for the rule of law. And I think it brings upon us a compelling question: where does it end? And what kind of message does that send to the next generation? If elected officials obey only the laws that they like, where does that lead us? That's the problem. If we're free to disregard any federal law that we disagree with, I think it opens a Pandora's box. And I think this box has been opened, and I think it's up to us to try to close it. Democratic self-government in a constitutional republic presupposes fidelity to the law. That's what makes our system work. And without that, we lead to anarchy. And if somebody disagrees, they have every right, like all of us, to work through the system to try to change the law. But we do that by convincing our citizens, convincing the electorate. We do it at the ballot box and not by outright defiance of the law. So, again, I just applaud you. I think this whole momentum that's begun for sanctuary cities is irresponsible. It's dangerous. and I think we have to stop it here today. So I'm fully in support of the bill, and I would move favorably at the appropriate time, although I know you'd like to do it as well. Thanks.
Thank you, Representative Johnson. Representative Carter for a question.
Here in the corner. What I see on your map here, I see the red dot for New Orleans. What's the yellow one behind it? What does that stand for?
I believe that's Orleans Parish, I believe.
So you got a parish and the city both.
Correct, yes.
Representative Hodges, I'm pretty much in favor of most of what you're doing, except I want to ask Mr. Kovach or Secretary Kovach about page 2, lines 24 and 25. Those give me some heartburn, and let me tell you why. To let a law enforcement officer just ask without any reason whatsoever somebody's citizenship or immigration status, to me, can lead to profiling. And I think that's one thing we've been trying to stamp out all over this country, is any kind of racial profiling or any other kind of profiling. And I would hate to think that a citizen walking down Bourbon Street in New Orleans can be stopped arbitrarily and says, "Where's your driver's license? Where's your passport? Where's your deal?" And that's exactly how I read page 2, lines 24 and 25. Are those really necessary? Look, if the guy's supposed to be detained by the feds, I'm for turning him over to the feds or
Representative
whatever.
Carter, are you looking at the original bill? And I'm sorry to interrupt you. Are you?
I'm looking at the only
this?
one that was in my thing.
It's a original bill, and then there's a substitute bill we announced, and I think you were a little late coming in when we announced that we were going to take up the substitute bill. It's right behind the original bill.
Well, is that still in the bill?
Representative Carter, I think there's some confusion. The statute does not,
It's still in there, except it's lines 17 and 18.
Yes.
as I interpret the statute, it's my opinion, what the statute does is allow the law enforcement officer, once he takes the person into custody, okay, so if he has probable cause to believe that person has already committed a crime, as part of that, as part of his questioning, he is allowed to ask him his immigration status. Here's the problem we have. When you go to get a driver's license, you're required to submit a birth certificate. I wonder why. When you go to get a passport, you have to submit a birth certificate. I wonder why we do that. Why would we not allow our law enforcement officers a law enforcement tool, the same tool that we allow those who issue driver's license and passports, the ability to verify who that is?
Well, I think I've got a personal privacy right that if I'm minding my own business and I'm walking down the street, not to be accosted by a cop.
Absolutely, you do. Absolutely, Representative Carter, I agree with you. But this bill doesn't do that. This bill says...
Oh, it does. If you read 17 and 18 of the new bill, it says at any time they can stop you and ask you. Tell me why I'm wrong.
Go ahead, Chris.
Can I jump in here? First point, the bill doesn't direct the police officer to ask a person or create a situation where the police officer is compelled to ask. It just says that the sanctuary policy is one that prevents the police officers from ever asking. And so what it does is it retains discretion in the police officer. That's where virtually
you're giving him also the discretion to do it.
He already has the discretion to do it.
Every city,
no, he doesn't.
Yeah, every city in New Orleans, the police office. Every city in Louisiana already has this, except New Orleans now, where the police officers have always had the discretion to ask. And in fact, the United States Supreme Court in 2005 ruled specifically on that issue and said it does not violate anyone's constitutional rights if a police officer either just out of the blue asks a person his citizenship or immigration status, or in the course of a criminal investigation. It's part of determining who you are.
And what if he says no?
If the individual says, "I'm not going to tell you,"
I'm not going to tell you,
then the police officer can determine at that point if he has probable cause to make an arrest. He may not. If a person says, "No, I'm not going to tell you," he may say, "I'm standing my Fourth Amendment rights," and the police officer would have to have some other evidence to make an arrest. But the Supreme Court has said that merely asking this kind of identity information is part of what police officers, a tool they have to have as part of their daily operations. If an officer witnesses someone running away from a crime scene, isn't sure who he is, what's going on.
Can you see my worry about racial profiling?
Right.
More than racial, it could be religious profiling, it could be racial profiling, it could be cultural profiling. They doesn't like the tattoos the guy's wearing, so they profile him, you know.
Well, but I guess the question, Representative Carter, in all due fairness for law enforcement officers, if a crime has been committed in an area, take New Orleans, for instance, where it happens quite often, okay, and police are trying to get on the scene. They're trying to evaluate the chaos that a crime causes. People are walking by them. They have a witness that says that where there's a description of a person who may have committed the crime. The ability to go to the description of that person and ask for that person's driver's license, simply just asking him for his driver's license or immigration status or anything else for that matter, is a tool that law enforcement officers need in order to determine whether or not a person has committed a crime or to make sure that they apprehend a person who is causing the havoc inside of the community. Look, no one, and I appreciate your question. I think it's great that you raise it. There's no one out there. Look, I scored a 90 percentile above with Campaign for Liberty, all right, when I was in Congress. Believe you me, our individual rights is something I hold near and dear. But there's always a balance that we must strike. It's an important balance.
Will it do damage to the bill to take that one clause out, is what I'm saying.
Well,
what I'm
it
saying,
does because it's part of the definition. All it does is say that if a policy says, if a chief, a sheriff, a mayor places in that policy the prevention of law enforcement officers from asking those questions, it doesn't say that they must. It doesn't say that when they do, it makes it legal. What it says is that if it's placed inside the policy, okay, that is the definition of a sanctuary city. By taking that out, you gut the bill. That's what you do. Yeah,
No,
you do.
no,
You
no.
gut, well, because you gut the definition of a sanctuary city.
what I still think if there's a guy who ICE wants, let him have it.
Well, but how do you find out if it's him, though, in all due respect? How do you think he's going to just tell us? You think that he's going to tell a cop, oh, yeah, I'm here illegally, and by the way, I've committed tons of felonies before, and ICE has been looking to deport me. He's going to use an alias.
Well, what if he just said, again, I go back to the question that the secretary says, what if he just says, I'm not going to tell you. What you going to do then? You going to arrest him? What are you going to do? I mean, I just
You
don't want...
may take him into custody for further questioning,
Because
whereby
he
you would
didn't give you-
Mirandize him.
Because he didn't give you his ID?
Well,
I mean, that's not
Member-
against the law in this state.
That's not- refusing to
Representative
present
Carter, and we're just going to, this may help with what you guys are debating, RS 14:108 point, looks like 108A, B, C. And it states refusal by the arrested or detained person to give his name and make his identity known to the arresting or detaining officer, or providing false information regarding the identity of such party to the offender. And that's included in the definition of resisting an officer in current law.
But I don't believe he's got to have probable cause to do that. I don't think there's any probable cause requirement in y'all's bill.
Right, and it does come with probable cause in the current criminal statute.
And this does not require...
This isn't a crime that's being
This
Yeah,
isn't
but
a crime.
Representative
No,
Carter,
but
are
it's a
you...
reason to be detained.
This actually, a sanctuary city policy prevents a law enforcement officer from asking the question. All we're doing with this is saying you are allowed. We're empowering law enforcement to be able to ask the question if they need to. We're not telling them you need to, but if they need, right now their hands are tied. They cannot ask these
I
questions.
see this as a real possible abuse of profiling.
Can I give you an example of how this might be used? What you're describing, quite often you have gang problems in large cities in America. And as you know, MS-13 is a gang that has a high proportion of its membership are aliens who are illegally in the United States. There are some U.S. citizens, but there's some aliens as well. And it's a gang that spreads through through our prison system. Say the police make an arrest of 10 gang members. They're all MS-13 members. The police start interrogating, and they're all at the scene of a crime. Not clear which ones actually pulled the trigger, let's say. Police start asking questions. If it's discovered that 6 of those 10 MS-13 members are aliens who are not lawfully present in the United States, what most police departments want to be able to do is have the tool in their pocket of, okay, we're going to have to try to prosecute these 4, but these 6, let's get them out of the country because we know ICE makes gang members a high priority for removal. You can't, the police have no place to begin if they can't even ask the person, are you a citizen or are you a non-citizen? You take that tool out of the police department's toolbox, you really limit them in going after gangs like MS-13. And the Supreme Court has already ruled it. It's already in your state's law. You can ask somebody his citizenship. You don't have to. This bill doesn't compel anyone to do it. But you wouldn't want to take that tool. I promise you don't want to take that tool out of your police toolbox, because then all of a sudden they can't deal with these gangs.
Well, that's what bothers me. Say my son-in-law is walking down the street and he's got a tattoo that looks like a gang member's tattoo, like you said, MS-13 or whatever it is. Does that give the police the right, just because he's wearing a tattoo, to ask him, let me look at your citizenship papers?
Well, if your son so happens to be at the crime scene.
No,
I mean,
no.
you have to look
I'm
at
just
it's the
talking down
totality of the circumstances.
Nothing here about a crime
Representative
scene.
Carter, you are a very astute attorney. I know that. You know that what you're harping on is one component of what a police officer, a law enforcement officer, has at his discretion. Okay? Just you don't always walk around with only one tool in the toolbox. Okay? You want to give law enforcement officers the ability, and the law specifically requires that they have all of those tools, and that some of those tools are only able to be pulled out when certain facts exist. But what you're presupposing is that if your son is walking into the park on a bright and sunny day, in a nice peaceful park, with the birds chirping, and a police officer goes up to him and asks him for his driver's license, well, I can understand that. But do you want to balance that against the ability for us to apprehend violent criminals and take them off the street? I mean, how would you suppose that our ICE agents out there, in fact,
What about your
how do we
present law that-
enforce immigration as a whole?
What
How do
about
we
your present
determine if
law?
a person's here illegally or not? By not being able to basically ask them. So basically what we say is we can blow the door open on our house. We can invite whoever we want in, and we can't check them. We don't have the ability to simply act. Why do we have a driver's license?
I
But
don't
why do
have
we
a
ask
problem
for it?
the-
Because it's a privilege. That driver's license, asking a police officer, asking a law enforcement officer asking for the driver's license. You know why the Supreme Court has upheld that? Because that is not his right to have it. It's a privilege that the state confers upon him. Representative, the ability to a law enforcement officer to ask a citizen for a privilege that the state or the country gives them is perfectly within his
I
right.
have no problem asking. It's what's going to happen when he says no.
Well, that's what good lawyers for you are like. That's why we're trying to help you out here. Gonna give you a little bit of business.
I just see that
We're gonna help keep the bad cops off the street, Representative.
that
You're gonna help
one
us.
clause really gives me a problem with profiling. I think that it opens the door for profiling, and I think every city, and I'm for this 1,000%, that no city should say if there's a federal warrant out for somebody or the ICE warrant out for somebody, that they shouldn't have to pick him up and take him in. What I'm worried about is this being used as a tool to either harass or to profile somebody.
I
And-
doubt it will be, but I
mean,
we have choices we have to make in life, Representative. I understand.
I
But
just-
if you really want to do away with this, if you really want to protect the citizens of Louisiana, we have worked extremely hard to make sure that we have addressed as many concerns as possible. But understand that at the end of the day, we can't make everyone happy, but we can help to make everyone safe.
I want everyone safe. I just don't want everyone harassed. And I guess that's the weighing gets to be what is harassment or the possibility of harassment versus safety. That's why I would prefer if that sentence were out. But
Thank
I'm
you.
only one person.
Thank you, Representative Carter. Representative Brown for a question.
Thank you, Madam Chair. Secretary Landry, General Landry, I'm happy that you pointed out that having a driver's license is a privilege and not a right. That'll help us in our discussion on the Real ID bill next time on the floor. Much to dismay of Representative Johnson, because I think that goes against his right to liberty argument. Yes, it does. But my question, just briefly, and I appreciate what you're trying to do with this bill. I agree with the intent of the bill. Secretary Kobach, I guess one of my questions is, does the state of Kansas have a similar?
We have a bill that is almost identical to HB 151 that just got passed out of our House Judiciary, I think Judiciary Committee, and it has not yet had a floor vote. So we have a similar problem. We didn't have any sanctuary cities, and all of a sudden, or counties, and all of a sudden 6 counties popped up just in the last couple of years after the ACLU sent that letter out. So we're trying to pass a bill that's almost identical to this one. The difference is that ours doesn't take away bonding authority, it just takes away state funding.
Okay. And my final question, according to the chart, it shows that currently we only recognize that maybe there's 3 jurisdictions in Louisiana currently.
Correct.
Okay. I just wanted to make sure I was reading that or seeing that correctly. Thank you, Madam Chair.
Thank you, Mr. Brown, Representative Brown. Representative J. Morris for a question.
Thank you, Madam Chair. General Landry and Secretary Kovac, nothing in this bill abrogates the right of a defendant not to incriminate himself under the Fifth Amendment.
That's correct. It doesn't in any way change the rights of a defendant to speak or not speak, to have an attorney.
So if he's asked a question, he can take the Fifth and not answer.
Absolutely.
And nothing abrogates the obligation of law enforcement to have probable cause to detain someone.
That's correct. And nothing abrogates, I imagine every single law enforcement agency in your state has a non-discrimination policy and has a policy regarding probable cause about when they can begin interrogation. All of that stays in place. This just keeps options open.
Before a law enforcement officer has even the opportunity to ask someone about their citizenship, among other identifying information, they have to follow the Constitution and any state law with respect to detaining someone.
That's correct. State law, federal law, state constitution, federal constitution, all those protections remain in place.
And so the section here, merely F, that Representative Carter was referring to, only pertains to defining what a sanctuary city is and having a policy of absolutely not ever asking that question.
That's exactly right. So you're defining a sanctuary city has multiple definitions. One is a city that muzzles its police officers and says you may not ask someone his status.
And that's a clearly approved question by the Supreme Court.
United States Supreme Court 2005 said that any officer can do that, and you don't even have to have probable cause. The Supreme Court made clear.
Very good. Thank you, Madam Chair. Thank you for clearing that up.
Thank you, Representative Johnson, for a question.
Thank you, Madam Chair. I just wanted to, I'm over here doing legal research on the citation resisting an officer. It's RS 14, Section 108 that's been stated. There's 161 cases in the jurisprudence. I don't see anything that backs up your concern. The problem is, Representative Carter, is that the sanctuary cities, the whole point of this is that sanctuary cities, when New Orleans or any city adopts that as their policy, they defy federal law in this case, but also they're defying this statute that is currently in our code of laws, our criminal code, Title 14. So in effect, what they've said is you can't comply. This provision of our law doesn't apply in these situations. So I just wanted to make the point. I see this bill as a way to basically reaffirm what is already in our law. I just don't see how it's subject to abuse. There's all this case law that goes back to some version of this statute has been a part of our code for as long as our state's been around in some form, and it simply hasn't been abused in that way, and the courts are the check on that if it happens. So I just don't have the heartburn about that provision that you do. I just want to make that point.
Thank you, Representative Johnson. Representative Harris for a question.
Thank you all for being here this morning. I have questions simply because I've heard the three of you all state New Orleans several times in reference to what's going on and being a sanctuary city and all of these other things. I've had an opportunity to see some literature that was passed out in reference with from our sheriff's office. But just out of curiosity, have you all had an opportunity to look at the consent decree that the city of New Orleans, the city's police department, is under?
I have.
We have. Okay. in that consent decree, in section 183 of that consent decree, it deals directly with this particular issue. And I just wanted to read a couple things to you all. So I just want to make sure that we have the misconception that the city of New Orleans adopted this policy willy-nilly. This is something that we entered into a consent decree with the federal government. Mr. Secretary, I heard you mentioned that you once worked and did the work on the federal side. But what I can tell you is that I can recall going to Gallia Hall and having a meeting there along with then Secretary Eric Holder and now current Secretary of Labor, Thomas Perez, in which they presented this policy to the citizens of the city of New Orleans. In the policy, in section 183, Section 8, it states officers shall not take law enforcement actions on the basis of actual or perceived immigration status, including the initiation of stops or other field contracts. B, officers shall not question victims of or witnesses to crime regarding their immigration status. Nothing in this provision shall prohibit NOPD from assisting non-immigrant victims, witnesses, in obtaining U visa, T visas where appropriate. C, officers shall not enforce Louisiana Revised Statute 14:100.13, which the Court of Appeals of Louisiana, Fourth Circuit, has found to unlawfully preempt federal regulations. So we're not doing this because we choose just to do it. We're doing this because we're under a federal consent decree. And I just want to make sure that we point that out, because I just don't think that it's fair to the city of New Orleans and the elected officials and the citizens of the city to state that we're just being non-compliant with federal or with state law.
I appreciate you bringing that out, and I have looked at those exact provisions you're mentioning. When I said that, what my objection is to New Orleans' policy is the consent decrees. Take, for example, it says you shall not question the victims or the witnesses at the crime scene. With regard to their immigration status, the idea was you want to get people to speak, provide testimony about a crime that's just happened. Well, what New Orleans did is they, instead of just saying, okay, we're only limiting it to victims and witnesses of the crime scene, they said you can't question anybody in the city about their immigration status.
But I just read what the consent decree stated. So I guess the question that I would have for you all is, if we follow this particular piece of legislation that passes, what happens to the city?
You don't violate. Well, the city can change its policy to make sure that it's crafted within the consent decree. And I will tell you that this legislation in no way impacts the consent decree as long as the mayor adopts a policy that is not a sanctuary city. I would also, Representative Harris, because I know you're a very astute lawyer, know that sometimes in consent decrees, lawyers don't always look at everything. And I would bring your attention to Title 8 of the U.S. Code, Section 1324, where it plainly states. Now, remember, I would say that federal statute would preempt the consent decree, where it plainly, or the ability to enact a consent decree. Federal law would trump that the ability of a person to violate federal law. That law, in other words, if the person says, well, I got to do this because of a consent decree, but by doing so I break federal law, the judge would say that no, you cannot break federal law, you would break the consent decree. That section simply states that it is a felony to encourage or induce an alien to come or reside in the U.S. knowing or in reckless disregard of the fact that the alien's entry or residence is or will be in violation of the law. Okay? So I would tell you that we have the ability, and I will tell you that as the Attorney General, I will work with the city of New Orleans in order to ensure that the policy both conforms to this legislation and we adhere to the consent decree. But I think that it is an injustice to ask officials in the city of New Orleans to basically, because someone agreed to go knowingly break federal law.
I understand, however, with this consent decree, there was a federal consent decree monitor, along with a federal judge, that made sure that the provisions of the consent decree were vetted, not only just with the city of New Orleans, but were vetted federally.
I would say they missed something.
Mr. Attorney General, I mean, I truly understand, but again, what you all are doing there's not a problem with bringing this particular legislation, and I don't. Let me be clear, I'm not here saying that I oppose what it is you all are doing, but as you stated, and if we look at the previous bill, when you start talking about crippling a municipality or a parish by stating that you can receive no state appropriations or no state, let me finish, you can receive no capital outlay, then we currently have a bill that states we take that away, but we now state that you pretty much will not have bonding capacity. So it's ultimately the same thing if we look at it. And I'm just not willing to allow the city to be put in a position such as that. And I think everyone in this room and on this DS would also agree, if the parish or your parish was put in a question like this, to not have bonding capacity or not be able to go to the State Bond Commission and bond, you would be doing the same thing that I'm currently doing and stating that, hey, this is just not right. It's not fair to us.
Representative Harris, I would say that you're not in any way taking away the ability of the city to access financing, or that you're not. What you're simply doing is making sure that that elected official has a choice. The choice is, if he changes his policy in a manner that protects his citizens, he has access to the funding. It's a simple right or wrong choice. My child, every day, I teach him the difference between right and wrong, but I can't compel him to be right or to be wrong. He simply has a choice. So you as a legislator are simply saying, look, the state, we have a compelling interest to make sure that our citizens are kept safe. And we believe that these policies impact the ability of law enforcement to protect our communities. And so you, Mr. Mayor, have a choice. So you're not taking away his funding. The ability to take away the funding is the mayor's choice. If he does not adopt a policy that is more in line with the rest of Louisiana, then he has made a conscious effort, a choice, to take away funding from his citizens. But no representative or senator here today on its vote in passing this legislation in any way takes away any citizen's right to access or municipality to access that funding. It is simply their elected officials' choice.
If you give us just a second, I'm sorry.
Sure.
We have an overflow room in Committee Room 2. The State Fire Marshal does not allow us to have so many people in this room. So if you do not have a seat, the front row is reserved for the press and members of the legislature. If there are any seats available, please find one. If not, welcome to committee. If you're testifying on a bill, we will bring some cards to Committee Room 2, but they've opened up Committee Room 2 next door for all that are standing. And they'll bring some cards over. If you're testifying on it, we'll retrieve those cards and call you at the appropriate time. There is a monitoring that room, and so you'll be able to monitor what's going on. And the Sergeant Arms will check and see if anyone needs a card to testify on any bill. Welcome to the committee.
And Representative Harris, I would tell
That's
you
the
that
second attorney, Mr. Attorney General.
I will make a commitment to you today in front of everyone that should this bill become legislation, and should that federal monitor have a problem with it, I will go personally, and you're welcome to join me in explaining to him why a change in policy is not a violation of both the consent decree, the Constitution, and federal law.
And I truly understand that this took place before you became Attorney General, so there's no, and we've worked together on some things, but just for clarification purposes, what I want to make sure people understand is that this consent decree was entered into 7/24/12 is when it became effective. So we're talking about 12. It initially started in 2010, in which our current mayor invited the feds to come and to see. Now, I'm here to tell you all that I am not proud to state that we are currently under a consent decree. And I don't think any one of us would ever want that to happen. However, it is something that has happened to us. And as I've stated, we've been under this mandate since 2012. It was actually approved 1/11/2013. So we're still some years, well before you became Attorney General. And again, I truly understand your concerns. I understand where you all have heartache and have issues with things that are going on, and many share your concerns. Also, Mike, we have to make sure we get the Attorney General to come when we do the real ID bill. Santa? Okay. Just had to
That's
throw.
normal. My big mouth has put me in a precarious situation.
We had to make sure we throw that in.
Think they're gonna want you in the Senate committee.
But no, I do understand. Jeff.
You know, Representative Harris, I will tell you, I love that city, and I believe this truly, that where goes New Orleans, where goes the state of Louisiana. And I believe that we have a crime problem in New Orleans, and I know that it's been festering. It's an epidemic. And I would only point to you all that if we are truly committed to doing something about the crime in our cities, and especially doing something about the crime in New Orleans so that we don't have the tragic events that happened just last week that so sobered the city, I would say that we should look maybe to New York and to look at the theory that they used in order to prevent or to basically abate their crime. And what they did is basically, this is one of those steps. Because what New York did in the 1990s was recognize that the way that you fix crime, that basically that crime is inevitably a result of disorder. And that in order to take disorder and make it orderly, people have to understand that there's a rule of law. And so what they did in New York, why it was the murder capital of the world, they decided to do something about the squeegee men. Okay, they decided to do something about misdemeanors. They decided to do something about urinating in public. That's what they did. They went in and because what it does is it sends a signal. It's a broken windows theory that basically says that if you walk into a neighborhood and there's a broken window and no one fixes it, that means no one cares. It's the same thing when we allow our citizens or we allow people to come into this country illegally. We send a message to the rest of our citizens that no one cares. We have a front door at all of our homes. You have a lock on that front door, Representative? Yes. Is there a reason why? You probably have two. Yes. I got two. I got an alarm too and cameras.
Attorney General Landry, and I'm sorry to keep interrupting you guys. At this time, because we've allowed the author to present her bill, but we have a couple of other bills that are going to have lengthy debates. I'm going to invoke the 3-minute rule on all testimony from this point forward from all individuals, because if we don't do that, we'll never get to the other bills and we won't get out of here in time to go to the floor. And I just want to make the members aware of that everyone else that comes up to testify will have 3 minutes to testify. Thank you.
Can I just add one quick response to Representative Harris? One other important distinction, which I'm sure you're aware of, is the same question can be prohibited in one case and permitted in another. So the question, are you a citizen of the United States? If it's intended to harass or profile someone in a way that is, racially or motivated by national origin, clearly prohibited. But if it's on a crime scene and you're asking someone who is a suspect, are you a citizen of the United States, then it's clearly permitted, and indeed it's necessary. So those kinds of distinctions are important in realizing that this proposed statute would not in any way prohibit New Orleans from complying with the consent decree.
You have.
Yes. Again, I truly understand. However, as stated, I know that we are currently under this consent decree, and it's something that we're mandated to do. So I have an amendment that I want to offer Representative Hodges in reference with, I think, to address that particular issue.
Okay.
I want to offer the amendment.
Staff will read the amendment in.
Members, there's going to be an amendment offered by Representative Harris to the substitute bill for House Bill 151 by Representative Hodges. The amendment is being passed around, and the code ends with 3168. So at the end of page 5, after line 12, the following language will be inserted. There'll be a section 3 that provides that this act shall not apply to any state agency, office, or department, or state or local political subdivision that is required by federal mandate or consent decree to adopt a sanctuary policy.
Representative Harris, on your amendment.
Thank you, Madam Chairman. What the amendment does is it gives us the opportunity, since we're under this federal consent decree, as stated, in this federal mandate, that entities that are under these mandates or these consent decrees, the provisions of this particular legislation won't apply to. So, Mr. AG, at some given point in time, I think if you would like to sit down with our mayor, with the federal monitors and others, I would hope that that's something that can be done. But what I, again, wouldn't want to do is to cripple the city of New Orleans, where we can't have bonding capacity, we can't bond projects, or possibly not be able to get, those sorts of things. So that's the purpose of the amendment.
Okay, Madam Chairwoman, I want to object to the amendment. It basically guts the bill. It makes the bill ineffective. It gives New Orleans a pass.
Representative Johnson on the amendment.
It will gut the bill. Obviously, that's the point of it, and it's not needed. Look, Representative Harris, when he was reading from the consent decree, let's all be clear about what we're talking about here. He cited RS 14:100.13, specifically mentioned in the consent decree, and somehow saying that Attorney General Holder and his colleagues said that we could no longer enforce that. Well, of course we can't, because that provision was struck down by Louisiana Supreme Court in 2013. They're stating the obvious. But that doesn't have anything to do with this bill. If you look that up, and I have it in front of me, that provision was part of the Prevention of Terrorism on the Highways Act that was passed in the wake of 9/11. So it was passed in 2002, and all it said in its relevant provision is in Part A, no alien student or non-resident alien shall operate a motor vehicle in the state without documentation demonstrating that the person is lawfully present in the United States. Okay, the court struck that down. You shouldn't have to carry your immigration papers around in your glove box. That doesn't have anything to do with the bill today. The language that we're parsing here, and that's what we're supposed to do on this committee, as attorneys and people who are handling our codes of law. Look at the language on line 1718. It says, and this would invalidate any sanctuary city policy that prevents law enforcement officers from asking any individual his citizenship or immigration status. It doesn't talk about documentation in the glove box of your vehicle. So it's a non sequitur. With this argument about the consent decree, there's no conflict between the two. The consent decree did not tell the city of New Orleans that it had to create a sanctuary city policy. If it did, it would be on its face unconstitutional and should be subject to challenge. So we can't adopt the amendment. It would make the legislation pointless. And so we need to oppose it.
And let's give us just a second. Zerain, Representative Zerain. He has another amendment. Who has a question? LaPinto with a question.
No, you got, which one am I on? You got Leopold on. There we go. Have you looked at the consent decree? All right. I do. I mean, look, I'm not opposed to the bill, but let's be honest, it does conflict with the consent decree. I mean, it is what it is. It says that they shall not question victims or witnesses of the crime regarding their immigration status. Okay, so I agree the New Orleans policy is overbroad. I completely agree that New Orleans policy is overbroad and a lot further than what the consent decree requires. But the paragraph here that prevents law enforcement officers of a state or local political subdivision from asking any individual his citizenship or immigration status is in direct conflict with the consent decree. I mean, I'm still going to vote against the amendment. I'm still going to vote for the bill, but let's be honest with what it does. It flies in the face.
Yeah, Representative LaPinto, I think they have a couple of amendments. The author of the original amendment has a statement on it that's probably going to satisfy the committee on this amendment. Representative Harris on your amendment.
Representative Hodges, Attorney General, the intent of the amendment is not to kill the bill. So I'm going to withdraw that amendment, and we're going to make I'm going to offer a different amendment, a substitute amendment, that'll make it more precise than with the amendment we just did. So I just want to let you all know I will withdraw that amendment and offer a more clear amendment.
And Attorney Johnson is going to explain that new amendment. Fontenot, I apologize.
Unless Representative Johnson would like to explain it. Members, I believe, and Mr. Harris can correct me if I misunderstand, but I believe that the intention of the amendment, if you look on page 3 of the substitute bill, the subsection C of 1404, subsection C, with respect to Joint Legislative Committee on the Budget, that language would come out. Also on page 3, lines 21 through 29, and following on page 4, the language with respect to sending notice to the State Bond Commission, that language would also come out. On page 4, lines 15 through 29, and all of page 5 with respect to the sanctions with respect to State Bond Commission would also come out. Am I understanding that correctly? Removal of the sanctions, and also, members, if title adjustments and would also have to be made.
Representative Harris on your amendment.
Thank you, Madam Chairman. Ultimately, as it just stated, what the amendment does is it gets to the core piece in reference with the Bond Commission. As I stated, I would definitely not want to have the Parish of New Orleans, City of New Orleans, however you so choose to call it, not be able to have the capacity to bond projects based upon an agreement, consent decree that we're currently under. So that's the intent of the amendment.
Representative Brown for a question.
I guess just a comment real quick. I want to agree with Representative Lopinto. I read the consent decree several times over and over yesterday, and I'm not looking at just bullet point number 2. I'm looking at number 1. I believe where it says law enforcement shall not take any actions based on the actual or perceived immigration status of a, I don't know the wording that you use, suspect, I don't have it in front of me. To me, that appears to be in direct conflict with the consent decree, this policy. Now, I don't want to see, I want to see the bill go through, but I understand Representative Harris, and I wish that we could work those differences out today. And I was going to have a problem with the original amendment because I don't think the consent decree states that they have to have a sanctuary policy. I think it would be in conflict with the sanctuary policy statutes our bill. But I just wanted to point out that I understand Representative Harris's concerns, and I do echo Representative Lopinto's that my reading of the consent decree over and over just seems like it does conflict with what we're trying to do here. And that's just my opinion.
Thank you. Representative Hodges.
Well, I want to object to the amendment. Basically, what that amendment does is takes all the teeth out of it. And as Secretary of State explained earlier, this is already in federal law that you cannot create sanctuary cities. But there's nothing with teeth, and that's all we're trying to do. Look, I love the city of New Orleans. I believe it's the biggest draw to Louisiana. It's got great tourism, great food. New Orleans has been the face of Louisiana. But what we don't want is a city that is harboring criminals. And I know all of you agree with this is America. And it is a privilege to be here. To be living in America is a privilege. I lived in a foreign country for 25 years and would kiss the ground when I would come back. And when I was in that foreign country, I went there legally. I had to come back every 6 months and get my papers. And it was very tiresome with 3 little children. And we would make that 24-hour drive every 6 months to be there legally. And that's all we're saying. These people need to be here legally. There is a front door to come to America, and you can get those papers. But to me, it's un-American to say we're not cooperating with the federal government, we're not cooperating with ICE, we're not cooperating with Homeland Security if we have a criminal. And there is a case right now, there is someone in jail in New Orleans who committed murder in California, was convicted of murder in California, somehow made his way to New Orleans, and he was arrested for aggravated battery. He is in jail in New Orleans right now. ICE told me that they went to the police department and said, we want this man, we want to deport him because he's a felon, he committed murder, convicted of murder, and now he's committing crimes in New Orleans, and New Orleans said, no, we're not giving him to you. To me, that's outrageous, it's uncalled for, it's un-American. And that's all, we're setting the bar very low here. We're just saying comply with federal law, comply with state law. We are as, who was that you quoted, Mike? John Adams. We're a nation of laws. We're ruled by law. And that's all we're saying to the citizens in Louisiana, to the government officials who were elected to uphold the law in Louisiana. We're saying follow the law. Cooperate with ICE if there's a criminal that has committed a crime. And so, and we're giving, basically, if the Attorney General issues the opinion.
That's right.
Saying you
Only
are.
if.
Only if he issues an opinion saying you're a sanctuary city, we're saying that you're ineligible to go before the bond commission. We're not cutting off your council on aging. At first, the bill was a little punitive because it did cut off all appropriations, which is what I believe other states are doing, cutting off all appropriations, to say follow the law. That's all we're asking you to do is follow the law so that we can keep our citizens safe. But what we did, we said it makes you ineligible to go before the bond commission. The next time they meet, whenever that would be, it could be 6 months. It could be if I think the bond commission's going to, I don't know when they're going to meet, but anyway, if it's before the Attorney General issues the opinion, then it could be a year. We're setting the bar low. We're giving them time to make it right, to protect. It's more important. The citizens of Louisiana are more important than criminals being able to stay here. And that's all we're asking the elected officials to do, follow the law. So I object to the amendment.
If I could quickly, Madam Chairman, I won't take more than 1 minute. Just to think about what you're saying. That's the reason that I can tell Representative Harris with all confidence that I believe that this law in no way conflicts with the consent decree would be because if I would believe that it did, I would have to believe that the U.S. Attorney General would basically require a city through consent to be a sanctuary city, which would be in direct conflict with federal law. Now think about that. Federal law says that you cannot have a sanctuary city. So how can the federal government impose through a consent decree and force a city to violate federal law?
How can they do it?
I'll remind the witnesses that we're now under the 3-minute rule.
2 minutes.
With all due respect, Mr. Attorney General, I know this is a heated
I'm
debate.
used to being under 3. I know.
Yeah, so I apologize for that because we're going to follow that rule with everyone else that comes to the table.
Well, I would just add, in response to the Attorney General's comment, that's correct. A consent decree that's in conflict with federal law is not enforceable. If there were any tension or friction between the consent decree and this statute once enacted, that's the kind of thing that could be negotiated and litigated, and if the consent decree is overbroad, that could be a subject for a court to address. So I don't think that should be an impediment to passing the bill.
And I also remind the committee that we're on the amendment now. The amendment is only in reference to the issues of cities who violate this bill having implications on their appropriations and capital outlay. So if you have any questions on the amendment. Okay, are the lights not working? I'm not seeing. You're not blinking up here. There he is. That's Carl. No, this side is not working. Representative Kuzan, can you get someone up here?
Okay, I'll speak. Oh, thank you. I do have a question on the amendment, and also have a question on the bill once we get past the amendment. So can I reserve the question on the bill after? Okay, so this is on the amendment. Could Representative Hodges, Are there other places?
1 second, Representative Kusan, I apologize. If you are on the left side, right now we're experiencing a little trouble, so we're not picking up your questions. So if you can just nod to me or something, let me know you have a question. We'll do it that way. Thank you, until they can come in and fix it. And I've been informed by Representative Brown to ignore the other side. Go ahead, Representative Kusan.
Okay, thank you. Representative Hodges, in the statutory framework in the state of Louisiana, are there other places where we have this sort of penal language relative to failure to comply with state or federal law? Or was this, maybe through your conversation with our staff, new relative to this route? So did they have to come up with the language out of the blue, or did they pick it up from somewhere else about stripping the bond commission authority?
Well, what we had was originally was to cut off all appropriations to the city. And that's what other states are doing. Some have done it, some are in the process of doing that, cutting off all appropriations until they comply. The point here is not to cut off the money. The point is to get them to come into compliance with law. And so what we didn't want to do, we didn't want to cut off the Council on Aging and K through 12 and higher ed. We didn't want to affect that funding. And so to make it less onerous, what we decided to do was make them ineligible, as long as they are out of compliance with federal and state law, that they would be ineligible to go before the bond commission for projects in the upcoming
So as
future.
far as you know, this is the only place in the statutory framework relative to any compliance with any law for a municipality that we would be stripping the ability to go before the bonding commission.
There are some other cases. I can't tell you exactly what they are. I don't know if the attorney might know, but we had discussed that when we met 2 weeks ago, and there was an instance that the attorney gave me that I can't remember what it was, and so because of that instance, I said, okay, I think that's better than just cutting off all appropriations.
Appreciate it. Yes, so there are other
Yes,
circumstances.
yes.
Thank you.
Okay, Representative Morris for a question. And I ask members to remember we still have another sanctuary bill, and we also have a number of other bills that are going to be probably highly debated in this committee today. And I want to give everyone an opportunity that's drove down and come from out of town to have an opportunity at the table.
Thank you, Madam Chair. I think it's probably been covered. The amendment does eliminate all enforcement mechanisms from this bill. And without the enforcement, we're not going to see any results. And this bill, and the bill I have that's similar, is important to me to discourage these sanctuary cities. And I'll be the first to say I love the city of New Orleans. I'm a property owner there. My children have all lived there at one time or the other. I have one that lives there now, and my grandson lives there. My daughter was mugged in the warehouse district. She was a victim of crime. It was not an immigrant, but it easily could have been, and it was in broad daylight at 4:30 in the afternoon walking her dog. Anything we can do to make the streets of that city safer or important, and for that reason I join you in opposing the amendment that takes all the enforcement mechanisms out. Thank you, Madam Chair.
Thank you, Representative Morris. Representative Harris has offered up an amendment which there's objection to. Representative Hodges objected to the amendment. With that, Madam Secretary, please call the roll. Members, we're voting on Representative Harris' amendment. A yay for the amendment is in favor of it. A nay is opposed to the amendment. Thank you.
Jackson?
Yes.
Yes. Representative Adams? No. Representative Bagneris?
Yes.
Yes. Representative Brown?
Yes.
Yes. Representative Carter, Robbie Carter?
Yes.
Yes. Representative Kusan?
Yes.
Yes. Representative Harris?
Yes.
Yes. Representative Hazel?
No.
No. Representative Hodges?
No.
No. Representative Mike Johnson?
No.
No. Okay. Representative Leopold? No. No. Representative Lapinto? No. No. Representative McGee? No. No. Representative Morris? No. No. Representative Zarang? No. No. I have 6 yeas and 9 nays.
And the amendment fails to pass.
Okay, I'm sorry.
We have Representative Carter.
Amendment. Mine is very short. It just adds 3 words to the bill. It
I have the
line-
staff to read in that amendment for you, Representative Carter. Attorney Landry.
Members, on page 2 of the substitute bill, lines 17 and 18, the paragraph F will read, prevents law enforcement officers of a state or local political subdivision from asking an individual his citizenship or immigration status when probable cause exists to make the stop. So it adds the probable cause language to clarify that provision.
Representative Brown, it's your question. Well, Representative Carter on his amendment before we take questions.
What? Oh, we've already discussed it and all. I just think that before somebody should be either, to stop the racial profiling or other profiling, and for our privacy rights and to keep from harassment, make this law consistent with other state law that says if you're going to stop somebody, have probable cause to do it. Don't just line everybody up on the street and say, all right, produce your citizenship papers. I think that I value my privacy.
Representative Brown, is your question on the amendment? Okay. Can you?
It just remains.
Okay. Representative Johnson on the amendment.
I'm thinking that through. I was going to offer an alternative amendment, but maybe yours would do it, and I'm just going to toss this out so everybody can think about it. The provision that was cited in the consent decree by Representative Lapinto is Section 183B, and it says specifically that you can't ask victims of or witnesses to a crime for their immigration status, okay? What I think the bill is trying to get at is the perps, right? The bad guys, right? The suspects, okay? So we could amend the word on line 18, page 2, where it says individual, prevents law enforcement officers from asking any individual his citizen or immigration status. We could say that the term individual does not include victims of or witnesses to crime, and that would make it consistent with the consent decree. But maybe that doesn't go as far as saying, because I think, or maybe I'm asking this as a question to my fellow committee members, if we add the element of probable cause, maybe that makes it consistent with a consent decree, because if you have probable cause to stop somebody, obviously they're not a victim or a witness to the crime, right? They're the perp. So maybe that solves it. Maybe that is an amendment we should adopt.
Representative Johnson, what he does is bring in due process. This is a country based on due process.
Amen, brother.
Amen.
And if I'm going to be stopped and asked this, there ought to be a reason other than I don't like the way you dressed or the way you look or what you are.
And members, we're on limited time schedule. I think Representative Carter, was that Representative Brown with a question on this amendment, and then Representative Morris. As I'm
Thank you, Madam Chair. Everybody keeps focusing on bullet point B under Section 183, but we keep ignoring subsection A that says officers shall not take law enforcement action on the basis of actual or perceived immigration status, including the initiation of stops or other field contacts. To me, that covers that's not just witnesses. That's covering everybody, and that's the consent decree.
Representative Brown, is it my understanding, based upon your interpretation, that you believe that the Attorney General of the United States
Yes.
and the courts
Yes.
and the courts have required New Orleans to adopt the sanctuary city policy? Is that
No, I'm not saying they required them. I'm saying they required them to enter into a consent decree that conflicts with your sanctuary policy bill.
No, but you can't have a sanctuary city if you don't have a sanctuary city it doesn't conflict with this law. So what you're saying is that the consent decree requires the city of New Orleans to become a sanctuary city. If not, then there's no problem.
I'm saying that's the effect of it. But I mean,
But do you believe?
do you disagree with the?
U.S. Do you believe that the U.S. attorney?
Do you disagree with the language that I just read is saying what it's saying?
No, I understand exactly what it literally says. And that's why I believe that this legislation in no way impacts the consent decree, because I know what federal law is, and I couldn't in my wildest imagination believe that a federal judge or the U.S. Attorney General would in any way require a city in this country to be a sanctuary city. And so for them to claim that New Orleans was violating the consent decree, if I gave the opinion that they were a sanctuary city, they would in all essence basically say that their consent decree requires New Orleans to be a sanctuary city. I'm going to send the U.S. Attorney a letter today asking him for that.
I welcome you to.
I will. I mean, I'm going to.
Because I'm just reading the language.
Right. No, I know. But that's why I think we should.
I'm not saying
worry
I
about the
agree
name,
with
right.
it.
No, but that's why I think that this exercise is futile, because a number of us all agree with it. And so if we just left it in place, the ability to clarify that later on while still having a tool to keep our citizens safe is intact.
I'm for you.
I
I'm
know.
for you.
I
I'm
know,
for
but
you,
I
Bill.
wanted to- I know. I wanted to- I
I'm
wanted to-
for the intent of the bill. I just hate us putting mandates on people that conflicts with existing consent decrees that they've entered into with the federal government. And I indeed believe that what this consent decree, the way it reads, is indeed doing what you're implying, is that the U.S. Attorney has made the city of New Orleans enter into a consent decree that conflicts with United States federal law. The way I read it.
Thank you.
Okay. Thank you.
Representative Morris for a question.
Representative Carter and Mr. Secretary, it occurs to me, of course, before someone's detained, generally speaking, there has to be probable cause or some reason. And so I'm not necessarily concerned about the amendment in that respect, but in some instances, the question might be asked of a witness to a crime, somebody who's not been stopped for a particular reason. They happen to be there, and I don't want that to be used as a pretext, for not being able to answer that question, because some people aren't being stopped. They might just be a witness or somebody in the area. Of course, to arrest someone, that is to physically detain them. You can't do that without probable cause, except I guess under certain extenuating circumstances, being a material witness or something like that. But can you speak to that?
Yeah,
very briefly?
I think I see where Representative Carter is going with his amendment, but I think the way it's phrased, it would do things that you do not intend to do, because many questions are asked about a person's immigration status that are not in the context of a law enforcement stop, what we consider a stop. So, for example, it could be a number of individuals at a crime scene who have not been individually stopped. It could be someone who's been arrested for some other, and this happens all the time. And you want to have your law enforcement be able to do this. You've arrested someone for something that has nothing to do with immigration status, and then among the many questions you ask while they're in custody in the police station is you ask them, "Are you a citizen? What's your immigration status?" Well, but you say when probable cause exists to make a stop. Your amendment would say this bill only applies in the context of stops. When there's not been a stop, then cities are free to adopt sanctuary policies at will. Another context.
Guys, I'm reminding you that we're in the 3-minute rule. Representative Carter has offered an amendment to which I think who's objected to, which Representative Johnson has objected to.
Another amendment All right, I will.
He's offering a substitute motion, which is in line with the rules of the committee. Well, substitute amendment, I think. Are you?
You're right, it's not.
Yes.
But I was going to try it anyway. But I know you are, brother.
And Representative Johnson on his objection.
Yeah, just 30 seconds. I was in favor of the idea until I had a sidebar over here and realized that we are leaving out. No, Pete with the DAs, who has
Why is Lance Harris in this committee?
to up the ante on our dress code wardrobe. The problem I have with the amendment, Representative Carter, is that we're leaving out reasonable suspicion, which is a critical tool in law enforcement and part of our constitutional tradition, right? So, wait. So, if we adopt your amendment, we go too far and we take an effective tool away from law enforcement. So that's why I'm going to bring the another amendment in a moment that would exclude victims of and witnesses to crime from the definition of individual in line 18, which solves the problem, keeps us in compliance with the consent decree, which I think is unconstitutional anyway, which is why I'm having a problem with this. But it keeps the bill clean where we don't have a conflict for an immediate legal challenge. That's better.
Okay, Representative Carter is withdrawing his amendment, and seeing no objection to that, he's going to resubmit on amendment. Representative Carter.
You want to read it, putting reasonable suspicion in too?
Attorney Landry on the amendment.
Okay, on page 2, at the end of line 18, we're going to add when probable cause exists. Well, when probable cause or reasonable suspicion exists. So that should clarify everything.
Representative Carter on his amendment.
That's it.
That's it.
Can I just quickly point out one other context I was going to mention? And this amendment, even as improved, still would have a problem with that. One of the most important places where state agencies ask people their immigration status is in your prison system. And it's imperative that all prisons in the state and sheriffs just making arrests, that you ask every person in custody his immigration status, because you may not realize that you arrested someone for bank robbery, had no idea about their immigration status, but realized that ICE also wants to deport them. And ICE has been, ever since 9/11, encouraging state and local jurisdictions to ask everybody in custody. You don't have
That's once they're in custody, though, right? I think his amendment.
Arrest or in custody, but here you don't have the way this is worded with that amendment. That would prohibit a prison or a sheriff's office from asking someone in custody, are you illegal? Are you in the country legally? Are you a U.S. citizen? You want to be able to ask those questions of people in custody without probable cause.
Once you're in custody, you've had probable cause or reasonable suspicion because you've arrested them. So,
but there's no reasonable suspicion that you are illegally in the country to ask the question. So maybe you could.
When they book them, they find that. When somebody's booked, I figured they
you can ask. You have to ask their ID and you have to ask for their ID and everything. Once you're arrested, I guess I'm not understanding that part of it. Because once you're detained or arrested for something, then the police have the right to ascertain who he is and all of that.
Database and everything.
Yeah, so I'm trying to figure out how this amendment conflicts with that.
It implies that you have probable cause to believe the person is not legally in the country. You could say where probable cause or reasonable suspicion exists.
Prior to an arrest, maybe?
Prior to an arrest or that the person is unlawfully present in the country.
Okay, you want to withdraw and
No, I like what I got now.
You like what you have now?
Cut my deal with Supreme Court Justice Johnson over there. I'm fine with it.
Okay, Representative Carter. Representative Carter has offered up an amendment for which there is objection to. Madam Secretary will call the roll. And Representative Johnson objects. I need you guys to follow.
Jackson?
Yes.
Still, yeah.
Yes. Representative Adams? No. Representative Bagneris? Yes. Representative Brown? Yes. Representative Robbie Carter? Yes. Representative Kusan? No. Representative Harris? Yes. Representative Hazel? No. Representative Hodges?
No.
No. Representative Johnson? No. I'm sorry, Representative Robert Johnson? Yes. Representative Leopold? No. Representative Lapinto?
No.
No. Representative McGee? No. Representative Morris? No. And Representative Zarang? No. 6 yeas and 10 nays.
An amendment fails to pass. And Representative Lapinto for an amendment. And Attorney Landry will read that amendment in.
Okay. Members, Representative Lapinto has just offered an amendment to the substitute bill. So on page 2, line 18, I'm going to read the amendment into the record. So it's going to say, from asking any suspect or arrestee or person in custody his citizenship or immigration status.
Suspect, comma, arrestee. I have more of that, but
Okay.
it's for 3, right?
And that concludes the amendment.
Members, Representative Lapinto has offered up an amendment. Is there any objection to that amendment? Okay, guys, we have a number of bills, including one just like this one, and so if it's not on the amendment, please hold it until we get to the bill. Is this on the amendment, Representative Johnson?
Very quick. And I don't want to belabor the point, but obviously this is a very important piece of legislation
Yes,
with
it
huge
is.
consequences. I like that a whole lot better. I'm thinking out loud because we're doing this on the fly, which is kind of dangerous. But what I was going to propose is an alternative amendment that excluded from the definition of individual victims of or witnesses to crime. So I'm asking a rhetorical question to everyone to think: is what the Lapinto amendment does, is that a smaller subset? In other words, do we leave out anyone by just saying suspect, arrestee, or person in custody, by limiting it to those 3 categories instead of excluding 2 categories, which is victims and witnesses? No?
I like your amendment much better, Representative Johnson. I think it's more narrow of what it does do, and it's more in line with the consent decree. It's actually putting the bill in line.
Listen,
Representative Lapinto on your amendment.
the reason we don't want, by definition, a suspect is a witness to a crime. If we exclude witnesses of crimes, the suspect can say that, hey, I'm not. So here we have a suspect, an arrestee, or a person in detention, so we exclude those peoples. But by definition, a suspect is still a witness. That's the reason you take statements from them and you do it. So this excludes, it basically tells the policy you can't not question a suspect. But we're not excluding it from a witness. I mean, that's the reason why I think if you go the witness route, you end up putting yourself in, that trick bag.
I agree with that analysis. Appreciate that. I think I'm good with the amendment, and I'll support it. And then if we need to hash this out further, we can do it on the floor. Everybody agree?
Yes.
Okay.
Thank you. Representative Lapinto, Representative Carter for a question. Is there any, Representative Lapinto has offered an amendment which there's no objection to. Seeing no objection, the amendment is adopted. Is the board clear? Because I know the left side is not working. Representative Chad Brown. Oh, it's working now. Good.
Thank you, Madam Chair. I have an amendment that staff that I would like to address my issue that I had, if staff could read it.
And I think that's Attorney Fontenot
Yes,
on that
ma'am.
amendment.
Yes, ma'am. Madam Chair, and members of the committee, Representative Brown's amendment would go something like this. If a consent decree exists between a political subdivision and the federal government, the Attorney General of Louisiana shall submit a request to the U.S. Attorney General to determine whether the consent decree is in violation of the provisions of this act. Am I stating that correctly, Mr. Brown?
I think everyone likes that amendment. This may be the first time. Is there any objection to that amendment? And the board is working now. Representative Kusan for a question. It's on the bill. Do you have your button pushed? Trying to see if that board is working. You have it pushed now? Okay, it's still not working. Representative Morris.
Now it's working. It just came on. Thank you, Madam Chair. I just want to register an objection to that amendment. I think it might tie the hands of the Attorney General on this. And
Representative Morris, you do note that the Attorney General was fine with the amendment.
Oh, he was? Oh, okay.
Yes.
Well, I really am not, but I will draw it in deference to my objection in deference to the
Thank you.
Attorney General.
Representative Brown has offered an amendment. Is there any objection to that amendment? The board is working on your side, I believe. Oh, it's going in and out. Representative Johnson on the amendment.
There it is. I might object. I just have a point of clarification. Are we saying that we are going to subject the enforcement of this new law, should it pass, to a political decision of an appointee? I mean, in other words, the federal attorney general has to tell us it's okay to enforce this law in a particular city in Louisiana. Is that what the amendment does?
I'd like the Attorney General to.
No, look, I think that where we are in this is what we're looking for is language, whereby I would request the U.S. Attorney to tell me if the consent decree causes New Orleans to be a sanctuary city. Are you forcing New Orleans to be a sanctuary city through your consent decree? Does your consent decree mandate, because that's where we are today, does it mandate that New Orleans is a sanctuary city? It's a pretty yes or no question for the U.S. Attorney. If he in fact says no, we don't have a problem.
And I think...
But why do we, I don't, far be it, I'm with the Attorney General, but do we need that in the bill? Like, why do we need that in the legislation?
Well,
I think it helps us make his determination.
But we can do that independent of the legislation. We can have correspondence with the Attorney General and have a dispute, maybe even litigation over that, but it shouldn't have anything to do with with this bill, I don't think.
Well, Mr. Attorney General, let me get some clarity as well. If we enact a statute that's in direct conflict with a federal consent decree, then is the statute not unconstitutional on its face?
No, because are you asking me? I'll
The
tell you
Attorney
my opinion.
General.
Well, he's busy. The consent.
Well, I'm asking the Attorney General. Now, let's understand that the chairman is asking the Attorney General a question and would like an answer from the Attorney General.
Yes, Madam Chair.
Thank you.
I would rather let the court decide if we had to
I'm
go that
asking
route.
the Attorney General who's at the table a question, and I would like an answer from him.
yes,
What
ma'am.
was the question?
What was the question?
My question to the Attorney General is, if we enact a statute that conflicts with a federal consent decree, is that statute considered unconstitutional?
I would say only if the consent decree is constitutional.
And so the question is, I guess we would have to know from who whether or not this consent decree is constitutional.
Look, I think that absent, and I
And the only
appreciate-
reason why I'm asking is because I don't want us to be tied up in further litigation, and so
No,
the committee
I don't
needs
believe
to-
we are. I don't believe we are because I don't believe that's why at the beginning I believe that kind of going around and around over this issue is moot, because we all have agreed that federal law prohibits sanctuary cities. We know that as a matter of law, Madam Chairman. And so I can say with great certainty that this law does not conflict with the consent decree, because the consent decree cannot conflict with federal law. And so that's why it was at an effort I think Representative Brown's offer was in an effort to ensure that the Attorney General understood those issues. I understand them. We don't necessarily have to have the amendment in the bill or not. I am going to clarify this with the federal government. And so it's important to understand that this legislation is not automatic. I have to render an opinion before they lose that funding. Those cities always have a due process to come to the bond commission as well. You know, this was in addition to safeguards. I think the bill is great like it is. It's a matter of addressing certain legislators' concerns.
See, I went to law school with you. I knew you were capable of answering your own questions. Thank you. I remember you in law school. I knew you were very intelligent.
You made better grades than me. I will say
Yes,
that.
but I remember you being very intelligent. I figured you could answer your own questions. Okay, now Representative Brown, I think, has offered an amendment to which I think Representative Johnson, is that correct, has an objection to?
I do. I think it's more appropriate for a resolution, not a part of the bill.
Okay, and so Representative Brown has offered an amendment to which Representative Johnson has an objection to. Madam Secretary, please call the roll.
Representative Jackson?
Yes.
Yes. Representative Adams? No. Representative Bagneris? Yes. Representative Brown? Yes. Representative Robbie Carter? Yes. Representative Kusan? No. Representative Harris? Yes. Representative Hazel? No. Representative Hodges?
No.
No. Representative Mike Johnson? No. Representative Robert Johnson? Yes. Representative Leopold? No. Representative Lapinto? No. Representative McGee? Yes. Representative Morris? No. Representative Zarang? No. The motion, I have 7 yeas and 9 nays.
And that motion fails to pass. Seeing the board is clear on amendments, Representative Kusan for a question, and reminding you guys that they're going to come back to the table for closing, but we have a number of witnesses yet to speak.
Thank you, Madam Chairwoman. General Landry, Representative Hodges, I'd be remiss if I didn't mention that there was another sanctuary city mentioned in testimony and in the report presented to us by Secretary Kobach, and specifically that's Lafayette Parish. And of course my district falls right in the middle of Lafayette Parish. And I wanted to read to you the part of the report. And basically it says Lafayette Parish has adopted a policy whereby it refuses to hand over an illegal alien criminal to ICE unless ICE first obtains a court order. This makes it effectively impossible for ICE to take custody of these criminal aliens. ICE does not have the time or resources to seek a court order every time ICE seeks to take custody of a criminal illegal alien. And you know, the concern that I have, and I like your bill and I'm about to vote for it, but this is our opportunity. I wanted to talk about Lafayette in particular. You know, it seems the ultimate irony that ICE does not have the time or resources to seek a court order, but we're putting an unfunded mandate on our local sheriff's department in this case, you know, to do what this bill is asking it to do. So I just wanted you to comment on that and you know, ask where are the resources to come from if let's say we're running a budget on, you know, on a thin budget right now. Are there more resources available from the feds, from the state, in these other states that have come through the same issue? And I'd appreciate it if you could respond.
Yeah, I appreciate the question, and I probably could have worded that more specifically. So it has more to do with the time frame this is happening in. So ICE learns that your parish has somebody they're about to release. They say, okay, we've decided not to charge him. We're about to release him, but we believe he's an illegal alien. And ICE says, oh, wait a minute, we want that guy. The clock starts ticking. The courts have generally held that there's a 48-hour time period. Mm-hmm. And so ICE has 48 hours to come over and take custody of that person. Now, if you've got to go to court, then that throws, it may be a weekend. And then you've got to go to court on Monday. And then the other problem is that ICE doesn't necessarily have an attorney at the New Orleans district office who's going to be able to go to court and get that done. They don't have the resources of the appropriate Executive Office of Immigration Review attorney. So it's a misconception that ICE can just make this happen really quickly and that they have an attorney who can run over to the court and get it done within 48 hours. So as
I'm not saying they have it. I'm just
Yeah.
saying the federal government prints money and our sheriff doesn't.
That's right.
So,
in a perfect world, maybe ICE would have all these attorneys sitting around waiting to run over and get these court orders, and the courts would be willing to accommodate them within a period of hours. But as a practical matter, it just doesn't work.
Representative Couson, but very shortly, this in no way is an unfunded mandate on Lafayette Parish. In fact, the issue is if ICE has 48 hours to get them, the cost of the parish is very minimum because they already have the guy in custody. So basically, what we're asking, what the sheriff should be saying is, ICE, we're going to give you 48 hours to come get this guy that you exactly want. If you don't come get him, they can't hold him there anyhow. So,
Yeah, well, I haven't heard from my sheriff, but
Right.
I'd like to work with you
Yeah,
as we
absolutely.
move forward. Should there be some funding issue on the local level that we can look at how to fill the gap? And I'm sure that these issues are going to come up not only in Lafayette Parish, where we have, to the extent that it's referenced, we have an issue, but also in Orleans Parish. So I'd like you to continue to work with our delegations together to look at the funding issues where we may have a gap. And I'd appreciate if you could do that for both of us.
Absolutely.
Thank you for that commitment.
Thank you. The board is clear. The board is clear. We have people who are in support of it. If you could clear the table, Representative Hodges, with your guests. I think we have a couple that want to speak. Judge Holliday, looks like. Present in support and wishing to speak. Harold McGee, representing SEIF, looks like, present in support and wishing to speak. We have Gene Mills with the Family Forum, present, not wishing to speak. And we have Mr. Dennis Burke with Self, present and wishing to speak, reminding all witnesses that we have adopted the 3-minute rule. If I've called your name and you're present and you wish to speak, that's Mr. Burke, Mr. McGee, and Judge Holliday. Please come to the table. And we have Brandy Mendoza present in support but not wishing, Melissa, I'm sorry, present but not wishing to speak. Judge Holliday.
Thank you, Madam Chairman, members of the committee. I had the privilege of serving on the Miami Immigration Court from 2006 to 2009. I wanted to offer you a few anecdotes to show you the difference of the outcomes that can occur when laws are enforced indiscriminately. I had one gentleman who appeared in my court who was from Broward County. He had been convicted of having anal, vaginal, and oral sex with his 13-year-old stepdaughter for that offense, and for a period of over 2 years. For that offense, he served a 3-year suspended sentence. This hit close to home to me because I spent 15 years in our State Department of Justice. And we had a secretary whose husband did the same thing with her daughter from a previous marriage. That gentleman is now serving life in prison. I could not send the man to prison as an immigration judge. However, as an immigration judge, I could send him back where he came from. And I did. He was on a non-detained docket. He had been released, was not detained by the Broward County authorities, of course. A young lawyer who represented many immigrants in my court was in the court hearing my decision that day. He got up, went downstairs, got the ICE officials, brought them back to the courtroom, and the man was detained as soon as he left the courtroom. Another example of how it works the opposite way was when I was sitting at a detained docket in San Antonio. There was a young man who was originally from Zimbabwe. He was a Zulu. He had, by ethnicity, he had been convicted of 6 counts of bank robbery. And he had served his time, and he was placed on a detainer and brought before me on that particular day, seeking relief from being removed or deported, removed is the term we use, to Zimbabwe. Zimbabwe of course, Robert Mugabe is a brutal regime and treats its political opponents brutally. And the Zulus are particularly singled out. The man's father came to testify, and the man's father took off his shirt and said, "See what."
Have
Mugabe.
about 30 seconds left on the testimony.
Thank you, ma'am. In any event, I would urge, it's the rule of, in any event, I gave him relief under the Convention Against Torture, where he would not be sent back to Zimbabwe. We have the rule of law in this country. That's why people come here. I saw them every day, and the stories that I heard every day would raise the hair on the back of your head. And they came here for one reason. That's because we're free. We do them no good if we turn our country into the same thing they came from.
Thank you, Judge
The
Holliday.
law makes that distinction. Thank you.
Thank you. Gentlemen.
Yes, thank you, Madam Chair. My name's Harold McGee. I'm representing myself here. I'm just a frustrated citizen. I'm no relation to Representative Tanner McGee. The city of New Orleans actually appeared on the sanctuary city list back in 2009. And in addition to all of the policies that were reviewed earlier, they also no longer conduct traffic control for federal agents on immigration operations. The city also passed a welcoming city ordinance in 2015, which provides for bilingual public employees and bilingual signage to facilitate non-speaking English populations. The city historically did not pass, in my opinion, a sanctuary city bill labeled sanctuary city because they feared the backlash that might occur. They actually changed policies with the NOPD and with the Orleans Parish Criminal Sheriff to create a sanctuary city environment. House Bill 151 is a law and order bill. It's not an immigration bill. However, those today that might appear in opposition to House Bill 151 will offer you justification that is based on economics and immigration and not law and order. Risk of deportation, racial profiling.
Have about 30 seconds left on the testimony.
Separating families, retaliation of witnesses, etc. They are not relative to the subject at hand, which is law and order. They will also identify that we are all descendants of immigrants, but that is an incomplete sentence. We are all descendants of legal immigrants. Thank you, Madam.
Thank you.
I'm Dennis Burke. I'm a concerned citizen, and I live in Metairie. I want to express my sincere appreciation to Representative Hodges for putting forward this bill. I urge passage of House Bill 151. It is a stand against the lawlessness of sanctuary cities. That lawlessness puts our citizens at risk and heaps unnecessary financial burdens upon them. No small amount of our current Louisiana fiscal crisis is attributable to the high cost of illegal immigration. The following is from the Federation for American Immigration Reform fact sheet entitled "Sanctuary Policy is Bad Public Policy." Sanctuary policies conflict with federal law. Congress adopted the Illegal Immigration Reform and Immigrant Responsibility Act of 1996 that prohibited state and local governments from prohibiting employees from receiving or sharing information on illegal aliens with federal government immigration officials. Sanctuary policies are expensive. The cost to provide education, health care, criminal justice, as well as general services to illegal aliens is $113 billion per year, a cost borne by U.S. taxpayers. The financial burden for Louisiana taxpayers in 2010, for example, was $213 million. It can only be much larger than that now. Sanctuary policies undermine national security efforts, with an estimated 11.7 million illegal aliens residing in the U.S. and fewer than 15,000 immigration and customs enforcement officers. It is clear that sanctuary policies seriously diminish our national security efforts. By removing a crucial component of interior enforcement, state and local law enforcement, sanctuary policies essentially create an environment to where terrorists and other criminal aliens can go unnoticed and uninterrupted. Endangerment to the citizens of our state aside, passing this bill that promotes the rule of law by partially defunding lawless sanctuary cities will free up much needed funds to help remedy Louisiana's current fiscal crisis. In closing, I ask the simple question: is the term illegal so difficult to comprehend? Legislators that encourage or allow the lawlessness of sanctuary cities are abdicating their responsibility. What else is a citizen to think about the unnecessary endangerment of our legal population and the unnecessary worsening of our state's financial crisis caused by illegal immigrants? Thank you for this opportunity.
Thank you for your comments. We have a number of people in present but not wishing to speak that are not in support of this bill. In opposition to the bill, we have Susan McGee with self, not wishing to speak. Rob Tasson with Louisiana Conference of Catholic Bishops, not wishing to speak. Looks like Chloe Segal with Congress of Day Laborers, not wishing to speak. Mr. Toro with Congress of Day Laborers. Alfredo Carrero with Congress of Day Laborers. Samar Autry, Stand with Dignity. Fernando Lopez, Congress of Day Laborers. Santos Alvarado, Congress of Day Laborers. Olga Morella, Congress of Laborers. Ann, can't read that last name, with Congress of Day Laborers. Colette Torrey, looks like, with Stand with Dignity. Christian Rhodes, Convention and Visitors Bureau, not wishing to speak. Matt Gresham with Port of New Orleans. Scott Kilpatrick with Louisiana, with the Louis Armstrong Airport. Scott, looks like Parker, not wishing to speak. CJ Rhodes with looks like the Convention Center. Kathleen Bourne, GNO. Deb Harkins, School Board. Dave Bessie, Self. Reverend Vandera, Greater New Orleans Christian University, looks like. Sarmiento with the Congress of Day Laborers. Rodney Braxton with Sewage and Water Board. Terrence Lockett, GNO, Fair Housing Action Agency. Ann Steer with National Association of Social Workers, Louisiana Chapter. Mr. Finkel with Southern Poverty Law Center. Rodney Braxton with the City of New Orleans. Mrs. Will. Reverend Week with Community Church. Mr. Walter. Angeletta Brown with Self. Nikita Shavers with Self, for herself, speaking, filling out the court for herself. Mrs. Miranda with Planned Parenthood, speaking for herself. Eva Tohei, Penelope Tohei, Dave Bessie, Reverend Biddle, Joel McGee with Planned Parenthood, Mr. Fincher, Keenan McGolan with Planned Parenthood, Wesley Baya III, Miss Doris, Charlotte Wilcox with Planned Parenthood, Kelsey Klein with Planned Parenthood, Paige Thibodeau, Kyla Peterson, Jeanne Bernard, Richard Ely, Melanie Asminger with GNO, looks like, Lori Miller with Planned Parenthood, Mary Barnes with Planned Parenthood, Julie Johnson with Planned Parenthood, Charlotte Arpedo, Jody Manali, Margaret Walker with INO, Reverend Derry Roick with Unitarian University Universal Religion. Those are all present in opposition but not wishing to speak. We do have some in opposition wishing to speak. We have Dr. Susan Waja with Jesuit School Research Institute, if she would come to the table. We have Zach Butters, it looks like Buttersworth, representing New Orleans, if you would come to the table, and Timothy Averell with New Orleans Police Department. Are those three persons who are?
New Orleans Police Department in New Orleans represented by three folks.
Okay, I called three people up to speak. Susan Weiser at this time, Zach Buttersworth, and Timothy Averell. Okay, we're calling you up in order as we have your cards turned in. So if those three would come at this time. Thank you.
Hi,
Morning. State your name for the record.
Zach Butterworth. I'm the Director of Federal Affairs for the City of New Orleans. I'd just like to note that Commander John Thomas is the head of our compliance division and helped draft this policy and may be able to best answer any questions about it. So Chief Tim Averill is also with our compliance division, an attorney there with the New Orleans Police Department, and then I'm with the mayor's office itself and have helped coordinate the policy between the mayor's office and NOPD and federal officials. I'd like to start off by saying that
Mr. Thomas, if you can prepare to come up, I'm sure there will be questions right after this 3-minute testimony.
I'd like to start off by saying that the NOPD complies with all federal law. We made sure in this policy that we're complying with every law. And to make this point, I'd like to put a letter into the record that Mayor Landry sent to Attorney General Loretta Lynch and Secretary Jay Johnson, where it reads, it notifies them that we had adopted this new policy and reads that if you or any officials within your respective agencies feel that this policy does not fully comply with any federal law, I urge you to contact the Office of the Consent Decree Monitor before the federal court that oversees this consent decree and notify them of any such infractions of federal law. And I can have a copy of this letter entered into the record. I'd also like to point out that this bill goes much further than federal law. If it simply wanted us to follow federal law, it would just say, please follow federal law and the AG can enforce that law. But it doesn't. It goes much further. And because of that, we had this conflict that we've talked about. And people can't figure out why the consent decree conflicts with federal law, which conflicts with the statute. It's because the proposed bill goes much further than all federal law. Now, how was this policy written? Chief Averill and Commander Thomas can go in depth, but simply put, ICE was consulted, a U.S. federal court was consulted, DHS at its highest levels was consulted, as well as the Department of Justice, Civil Rights Division, and the Office of the Consent Decree Monitor, all of which their sole purpose is to make sure that New Orleans is complying with all federal laws. Lastly, since we're on the 3-minute rule, I would just note that as much respect as I have for the AG, he cannot be the sole arbiter of who is and is not a sanctuary city in this state. That would restrict the due process rights of citizens in New Orleans from being able to challenge the fact that the AG has made these determinations. And I'd say the AG in his testimony mentioned that the city of New Orleans could come before the bond commission. Well, I don't believe the bond commission would be the appropriate place to challenge whether or not the city of New Orleans is a sanctuary city. So just to close quickly, I would put the letter from Mayor Landry to the Attorney General of the United States, Loretta Lynch, to Secretary Jay Johnson into the record that requests that they contact the Federal Consent Decree Monitor if this policy in any way violates federal law. Thank you.
Thank you. Mr. Thomas, if you can begin to wake your way up to the table, I think, is that, okay. And next, if you just state your name and.
Good morning, Madam Chairman, members. My name is Tim Averill. I head up the Compliance Bureau in the New Orleans Police Department. Representative Harris mentioned a few of the points I was going to make, but I'll restate the obvious with a few points. The first is that the signatory on our consent decree is the United States of America. The United States of America signed this consent decree through the Department of Justice. The second point is our policy was vetted by two big entities that oversee our operations. One, it was enthusiastically approved and supported by the United States Department of Justice Civil Rights Division. Two, it was approved by a group of federal monitors who oversees all of our consent decree operations to ensure compliance. In their approval letter on the immigration policy, they said, the policy incorporates all requirements of the consent decree and sets forth clear and appropriate rules to guide officer conduct. I would also note the obvious is that immigration law is federal law, not state law. So a lot of this discussion has to do with compelling state officials to enforce federal law. Two, if you look at all our policy, I want to make sure it's abundantly clear, and Chief Thomas can speak to this, all criminal law violations will be enforced by the police department. The issue about immigration enforcement that's outlined in the policy has to do with civil immigration enforcement. Administrative warrants. If a police officer calls in on a stop and there is an outstanding criminal warrant, it will be enforced. I want to make that clear. The issue that's under consideration is the enforcement of civil immigration policy. Obviously, we're here to express respectful opposition to the bill. A lot of the reasons for our opposition were outlined by two very important entities, major chiefs of police in major cities, as well as the International Association of Chiefs of Police. Their voices have not been heard, but I want to outline some of the concern they have voiced by requiring local officials to enforce federal immigration law. One, requiring state officials and local officials to enforce federal immigration law undermines the trust and cooperation with immigrant communities, which are essential elements of community-oriented policing. And this is not me talking. This is the Major Cities Chief Police Association.
Thank you.
Two, local agencies do not possess adequate resources.
Sir, we're under the 3-minute rule, and we've gone over the 3 minutes. I apologize, but we have so many people here to speak and so many other bills, and it's not that we don't want to hear from the city of New Orleans, but we've just invoked the 3-minute rule.
Yes, ma'am.
Yes, ma'am.
Yes, good morning. Thank you, Madam Chairperson and members of the committee. My name is Sue Weischer. I'm with the Jesuit Social Research Institute at Loyola University, New Orleans. JSRI works on issues having to do with race, poverty, and migration through the lens of Catholic social teaching. I'm hoping that a day before yesterday, the members of the committee received a petition that JSRI started that has already been signed by over 40 faith leaders in the New Orleans area. I'd like to introduce that into evidence, voicing their opposition to this bill. And we signed these letters out of grave concern for this legislation. Our sacred text reminds us that to love our neighbor and to welcome the immigrant amongst us is one of our most sacred obligations. We are a nation with a proud legacy of immigrants, and we appreciate what immigrants bring to our community. And in New Orleans, we're deeply grateful for the work of immigrants and helping to rebuild our city. A survey in March 2006 estimated that half the workers rebuilding the city were Latino and half those workers were undocumented. And why so many undocumented workers rebuilding the city? Because that's what our economy demanded. We are also opposing this bill because it's undermining the concept of local governance. the police department, the chief of police was appointed by the mayor of New Orleans, who was voted in by the citizens of New Orleans. The sheriff was voted in by the citizens of New Orleans. This is our city. These are our leaders. This is our policy. This is an affront to local governance. I would also just like to add that there's many reasons that you're going to hear opposing this legislation. It's the burden that it puts on the police. It undermines public safety. It destroys the trust between law enforcement and immigrant communities. It ends up separating families, and it has questionable constitutional standards. Let me just also remind you that these are voluntary requests from ICE. It's been said ICE doesn't have the resources. ICE is the most well-funded law enforcement agency in the United States. Its funding has tripled since 1990. It's almost $20 billion. They have more funding than the FBI, the U.S. Marshals, the Secret Service, the ATF. If they can get a warrant if they need it. And secondly, Secretary General, our Attorney General mentioned New York City as a very safe, large, big city. Yes, it is. And guess what? They oppose these policies. They have embraced policies that say police and the jails should not cooperate with ICE authorities unless there is a warrant. Due process, the Constitution. Thank you.
Thank you. And Chief, we didn't have your identity on your card, so we didn't realize you were in the audience, but please go ahead.
I apologize, Madam Secretary. Just to carry on what Chief Averill was saying, we work very hard on this policy, and some of the things that were brought up is some of the local agencies not possess adequate resources to enforce these laws, in addition to the added responsibility of Homeland Security. Just like DHS have limited resources, so does New Orleans Police Department. And as we try to combat violent crime, that just takes away from it. And as Representative Carter so eloquently said, we talk about reasonable suspicion and probable cause is our standard. And I think we have to understand that the Sheriff's Office and the Police Department work independent of each other with separate policies within Orleans Parish. And we're talking about detainees and releasing people out of our jail system. That is solely a Sheriff's Department responsibility. Immigration laws are also very complex, and the training required to understand them is significantly detached from the core mission of the local police department to create safe communities. Local police do not possess clear authority to enforce civil aspects of these laws. I did some of the research as it relates to ICE warrants. Any ICE agent, separate and apart from a third party judiciary, can actually put a warrant into the system. Now, we worked with Department of Homeland Security. That's how we could fix that, and they said they were going to be pulling them out of NCIC, but as it stands now, there's no fact to say that these warrants are taken out of the system, which can be put in by any ICE agent, a street agent with no oversight. And finally, the lack of clear authority increased the risk of civil liability for law enforcement in the government, that we can possibly be sued for violating civil rights. And I'll take any questions if you have any.
Looks like the board is clear, and we have one more person to speak in opposition, which is Mr. Fernando Lopez with Congress of Day Laborers.
Thank you, Representative Jackson.
Thank you. Welcome to the committee, Mr. Lopez.
Thank you. Good morning. My name is Fernando Lopez. I work with the Congress of Day Laborers, which is a community organization based in New Orleans. It was founded after Hurricane Katrina, and despite of different, the great amount of abuses against workers in general. So just one of the things that we've been working really close. We work really close with the Sheriff's Department and also the Police Department on the two policies that happen. And just to be very, very clear, there's no such thing as sanctuary cities policies in Louisiana. They're not out of the sanctuary cities movement. They were ruled by a judge, and they were based on court settlements. So this language of sanctuary city keeps being brought up because it's very sensitive, and of course people are receptive to it, but I just wanted to talk a little bit about what happens actually on the street when laws like this are applied, because it's really different from what it looks on paper than what happens on the street. So I personally have documented almost 100 testimonies from different people, including citizens, where ICE has the authority of using databases from local police agencies. We don't really know what's happening out there, and this has been the result of violations of even citizens just being grabbed out of in the street for no reason, not being even asked for their identification, just based on their racial profile. And just talking a little bit about the policy also that happening in Orleans Parish, this has really helped to build trust with the police, between the community and the police department, because there were many issues happening before that, and we could just not really approach. A lot of people were, especially undocumented residents, witnesses of different crimes happening on the street. And because of that idea of talking to the police will then follow deportation, people will be quiet when these things will happen. I'm sure Mr. Kobach does not know me, but I've been in different rooms with him across the states, in Arizona and Alabama, and now here in Louisiana. And it's always talking about these very controversial anti-immigrant or anti-undocumented
Got about
people.
10 seconds left.
Yes, and just to finish, when we were promoting this or pushing for the policy in Orleans, the Times-Picayune did a poll for the general population with regular people, and over 60% of that poll said that local police should not intervene on federal law, which
Thank
is
you.
immigration.
Thank you.
Thank you.
Just to let the committee, those who are guests that are waiting on other bills, know what we're doing. We're going to wrap up Representative Hodges' bill, and we're going to quickly take up a bill by Robert Johnson, and the Attorney General has agreed to let him go next, which is going to be House Bill 1123. Representative Hodges, if you can come back to the table, that concludes the opposition on your bill, and we ask that you guys be brief in your wrap up because we have so many other bills, and then we're going to go right back to Jay Morris' bill. So right after this bill, we're taking up House Bill 1123.
Jeff, you go first and I'll close. You want to say something? You want to say something?
Yeah,
And then I'll close.
I might just add a couple of responses to some of the comments that were made by opponents. One opposing attorney mentioned, well, the consent decree was vetted with the Department of Justice Civil Rights Division. That must mean that everything's okay. With all due respect, the current Department of Justice has become very partisan and has decided that in the case of certain immigration laws, they do not wish to see federal law enforced, and that's what the Fifth Circuit recently upheld in the case of Texas versus the United States with regarding the executive amnesties. So merely saying that the Civil Rights Division has put a stamp of approval on it doesn't hold much water, and it pains me to say that as a former Justice Department employee. If you really want to say that something is consistent with federal law, you now have to go to a federal court. You cannot take this Justice Department say so. There seems to be a little bit of confusion about what a sanctuary policy is. Maybe I wasn't clear enough. There are really three different kinds. There's the don't ask, the don't tell, and the don't respond to an ICE detainer request. The one that is prohibited by federal law is the don't tell. Don't tell the feds you've got an illegal alien. But there are other sanctuary policies, don't ask the alien his status, and don't respond when ICE wants to take custody, that aren't expressly prohibited by federal law. They're implicitly prohibited by the provision that the Attorney General mentioned. They're clearly inconsistent with that. But I just want to clarify that all of these sanctuary policies are generally inconsistent with federal law. One of the three types is expressly inconsistent, but the bottom line is they all endanger the people of your cities and parishes. The final point was made about local police shouldn't be forced to enforce anything. This bill doesn't force local police to do anything. They can choose to deploy their resources where they want. It doesn't force them to go out onto the streets and start asking questions at all. So I think that's a red herring. This bill is simply ensuring that you do not adopt sanctuary policies in your state that would endanger your citizens.
Thank you, Mr. Secretary.
Madam Chairman, I want to say may God bless you for having to chair over a committee of so many lawyers.
Yes.
And I would simply say I think it's important to understand that a person who is here undocumented is here illegally, okay? and that if we are going to establish and continue a rule of law, it is important that we support law enforcement in its ability to uphold a rule of law. And I think no one basically believes that we should create zones in this country whereby any particular person or class of people are above the law. So thank you.
Thank you.
Okay, members, Madam Chairwoman, I just want to say thank you all. I know it's been a long, arduous testimony. I think we've heard both sides of it, and I really appreciate it. As we've stated over and over, this is about the rule of law. It's not about punishing anyone. We love everyone, but we are a country founded on the rule of law, and we must uphold the law and require elected officials and others and our citizens to uphold the rule of law. And so that's all this bill is really about, and I would just ask for your favorable passage.
Thank you. Representative Harris for a question.
Thank you, Madam Chairman. Representative Hodges, I appreciate the passion that you have for this particular piece of legislation. I know it's your conviction, and I'm glad to see that we as legislators bring things to this body that we feel are important to ourselves and to our constituency. Again, the merits of the bill was never anything that I had any contention with. However, based upon, and as we had lengthy debate and discussion, based upon a consent decree that I'm not proud of, that we had to enter into, that was always my issue, my concern. So I just wanted to make sure that we had that understanding. AG Landry, I appreciate your hard work for the state, what you're doing. You mentioned that you were going to write a letter to the U.S. Attorney. Can you explain to us exactly?
Yeah, I intend to write a letter to our U.S. Attorney in order to ask him, it's her now, it was Eric quoted in, my apologies, if it was the intent of the Department of Justice to force New Orleans to become a sanctuary city, to adopt policies that are contrary to federal law. If that was the intent of the consent decree and in the language of both A and B, I believe it is, that Representative Brown and yourself both pointed out. And so that the intent is to craft a correspondence to the Department of Justice and Attorney General Lynch now,
yes,
to ask them if that was the intent.
All right, thank you. And when you receive that response, can you get this committee that response back, as well as send it to our mayor to let him know what the response is?
Yes, sir.
All
Absolutely.
Right. Thank you.
Thank you. On chairman's privilege, I'm going to say this. I've not said much or asked many questions on this bill. I wholeheartedly agree with what you're doing, Representative Hodges. I don't believe in sanctuary cities. However, I'm going to caution you guys moving forward, because I'm not going to object to this bill coming out of committee, and so I want to really make a statement regarding the appropriations to the people of New Orleans and capital outlay. I believe that when a local elected official refuses to uphold both state or federal law, that they should be held accountable. I'm a little bit concerned that this bill holds more than them accountable in its current posture, so I'm going to really plead with you guys to work on that from now to the Senate. Because as I see it right now, with the appropriations and capital outlay language, it holds the Council on Agents accountable, because that's part of New Orleans appropriations. It holds the children accountable. Their public schools are part of their appropriations. It holds the colleges and the universities that are located in New Orleans that have cooperative endeavor agreements with the city of New Orleans accountable. I don't think that that's the intention of anyone on this committee, to hold constituents accountable because the local elected officials will not uphold the state or federal laws. I am wholeheartedly against cities which do not uphold state and federal law. So I'm wholeheartedly against sanctuary cities. But I would caution the Attorney General, with all due respect, and Representative Hodges, from now to the floor when the bill moves to the Senate, because I hope it passes, but I'm concerned with the sanctions, if that we can work on some sanctions that actually do not hold the people of New Orleans, who have no skin in the game, can't force the local elected official to act accordingly. I think more appropriately what that's called is malfeasance in office. And that's my only concern with the bill. And I would just encourage you throughout the process to consider the people of New Orleans.
We'll do it.
Thank you.
And I want to say a special thank you to Secretary of State Chris Kobach for coming, taking the time and be with us and explain that what an important issue this is, as we all understand it, as we, chaired the task force last year. And a piece of a country without borders is just a piece of land. And I think we all understand the ramifications, and especially when we have criminals that are not being deported, how important it really is to keep our family safe, our children and our grandchildren, and the ones we love. So I appreciate all of your understanding, and I know we all agree on this issue. And so I just want to say thank you again.
Thank you. Representative Hodges has made a motion to move House Bill 151 as substitute bill to House Bill 151 favorably. Is there any objection to that motion? Seeing no objection, substitute bill to House Bill 151 is reported favorably. Substitute bill, that's what that is. As amended.
Thank you.
Thank you.